This case raises important questions of legal principle concerning the basis on which the courts may review the exercise of presidential powers. Okay, let's actually start right there. That quote is straight from the Constitutional Court of South Africa, and man, does it perfectly hook us into the massive legal and constitutional stakes of today's explainer. We are looking at a literal collision between the highest office in the land and the highest court in the land. Welcome to today's explainer. I am absolutely thrilled to guide you through this, the fascinating anatomy of a truly historic legal reversal. We're going to unpack a monumental constitutional court judgment involving President Nelson Mandela, South African rugby, and the absolute limits of executive power. And, as always, we're keeping things entirely impartial here. We'll be focusing strictly on the legal principles and the constitutional mechanics that make this case such a masterpiece of jurisprudence. All right, let's dive into this. Here is our roadmap for today. First, we'll hit the battle for SA Rugby to set the scene. Then, we'll examine the abdication fallacy, unpack the completely unprecedented cross-examination of a sitting president, define his precise powers, and finally break down the ultimate ruling. Moving right into Section 1, the battle for SA Rugby. So just following the deeply unifying 1995 Rugby World Cup, this massive controversy erupted. On one side, you had government officials and critics raising serious allegations about a lack of development, inadequate sporting facilities in townships, and a desperate need for transformation. But on the flip side, you had the fiercely independent South African Rugby Football Union, or SARFU, strongly resisting what it viewed as government interference in a private autonomous body. You can literally feel the tension building here. And those tensions, well, they ultimately triggered a series of legal dominoes. Fast forward to September 1997, and President Mandela officially appoints a commission of inquiry to investigate the administration of rugby. SARFU immediately challenges this appointment in the Transvaal High Court. And then, the High Court drops a bombshell. They actually set aside the president's appointment and, incredibly, made adverse credibility findings against President Mandela himself. It was a staggering ruling, and suddenly, the Constitutional Court was tasked with reviewing the whole shebang. That brings us to Section 2. The abdication fallacy. To understand where things went off the rails, we have to look at the timeline. The High Court's logic had a pretty fatal flaw. They zeroed in on an August 5th meeting between the president and the Minister of Sport, and a press release that came out afterward. But by hyper-focusing on that August press release, they completely ignored the actual, formal decision-making process that happened weeks later. It wasn't until September 12th that a massive 750-page dossier of evidence known as the Chwede file was delivered to the president. He reviewed it, he took formal advice, and the official Gazette notice appointing the commission wasn't even published until September 26. Now let's quickly de-jargonize a legal concept here. The High Court claimed the president had abdicated his power. What does that mean? Well, according to Baxter's Principles of Administrative Law, an abdication of power happens in 3 ways. 1, when an office bearer unlawfully delegates a power to someone else. 2, when they act under the dictation of another. Or 3, when they simply pass the buck instead of making the call themselves. And what did the High Court base this entire abdication theory on? A single hearsay quote from that August press release. The Minister of Sport reported that the president had told him, "A commission is yours if in your best judgment it is opportune." The High Court basically used this hearsay to claim the president had irrevocably abdicated his constitutional power, just handing the keys over to the Minister of Sport. But here is where the Constitutional Court stepped in with a brilliant legal correction. The crucial point is this. In law, an invalid delegation of constitutional power is a complete nullity. It's void. Therefore, and this is the real kicker, it can never be irrevocable. The court's logic was totally airtight. Even if the president actually uttered those exact words in August, an unlawful delegation has absolutely zero legal effect, meaning the president retained his full, undivided constitutional power in September when he actually sat down to review the files and make his official decision. So the High Court's assumption that the August conversation somehow permanently paralyzed the president's powers, it was fundamentally wrong. Okay, moving on to Section 3, cross-examining the president. This entire situation poses a vital question. Was the president actually treated fairly on the stand? The Constitutional Court introduced this fascinating recurring narrative thread here about procedural fairness and the fundamental rules of fair play in a courtroom. Which brings us to a really crucial legal principle, the rule in Brown v. Dunn. Basically, this rule dictates that there is a strict legal obligation to explicitly challenge a witness's honesty during cross-examination if you plan to later argue to the judge that they're lying. It's about fair play. You have to give any witness, whether they're a prince, a pauper, or a sitting president, a fair opportunity to defend their character and explain themselves while they are physically in the witness box. And this brilliantly illustrates the massive gap in the High Court proceedings. It's all about the missing cross-examination. See, President Mandela testified under oath that he carefully reviewed the September 12th dossier and consulted with his legal advisors before appointing the commission. SARFU's lawyers, they never explicitly put it to the president that this September review was a lie or some kind of dishonest charade, because the cross-examiner never actually accused the president to his face of lying about consulting his advisors. The Constitutional Court noted the High Court had absolutely no legal basis to reject his testimony and attack his credibility. Mind-blowing, right? Let's transition to Section 4, defining presidential powers. To explain the real crux of this reversal, we need to compare two specific types of legal power. Section 84, subsection 2, paragraph F of the Constitution grants the president the power to appoint a commission of inquiry. The High Court made the mistake of treating this appointment as a Section 33 administrative action. Now, administrative actions require strict procedural fairness, like giving affected parties a right to a prior hearing before a decision is even made. But the Constitutional Court clarified that appointing a commission is not an administrative action. It's a constitutional executive power. So no, the president was not legally required to grant SARFU a hearing before simply deciding to set up the inquiry. Now, just to be super clear here, the Constitutional Court didn't say fairness doesn't matter. The rule of fair play, or audi alteram partem, meaning listen to the other side, absolutely still exists, but the court clarified exactly when it applies. That right to a fair hearing applies later when the commission actually sits down to act, to investigate and to subpoena witnesses. It doesn't apply at the very beginning when the president is merely exercising his preliminary executive decision to form the commission in the first place. Finally, let's look at Section 5, the final constitutional ruling. The Constitutional Court's conclusions were unanimous and definitive. First off, the High Court judgment was completely set aside. Second, the president's appointment of the Commission of Inquiry into Rugby was declared entirely valid and lawful. And third, the court confirmed that the administration of a national sport like rugby was legitimately a matter of public concern, meaning it fully satisfied the requirements of the Commissions Act. But let's zoom out for a second, because we really need to highlight a major constitutional precedent established by this case regarding the separation of powers. The Constitutional Court actually issued a pretty stern warning about dragging a head of state into a witness box. They ruled that to protect the dignity, the status, and the efficiency of the highest office, the president should only be required to give oral evidence in civil matters relating to official duties under highly exceptional circumstances. This precedent ensures the machinery of government isn't just completely paralyzed by everyday civil litigation. The High Court had erred big time in forcing the president to testify over what basically amounted to hearsay in a press release. So this leaves us with a profound, lingering question to ponder. How do we balance holding our leaders accountable to the law with protecting the dignity and the vital function of the highest office in the land? This case proved that the Constitution remains supreme over everyone, for sure, but that courts must exercise their immense power with precision, fair play, and deep respect for the separation of powers. Thank you so much for joining me on this explainer. I really hope this deep dive into the legal mechanics helped illuminate this complex and historic battle.